Government of India has taken many steps in recent years to facilitate international trade in India. The inception of Customs Authority for Advance Rulings is one such measure helping importers and exporters in a big way. In this video, we will get to know about the importance of the Customs Authority for Advance Rulings, the benefits and the legal provisions. Advance ruling in customs is a written decision on the question raised by the applicant in his application in respect of any goods prior to its import or export. The authority in its current form has been working since January 2021. The provisions of this mechanism are in accordance with the mandate of the WCO Revised Kyoto Convention and WTO Trade Facilitation Agreement. The objective of the advance ruling is to enhance predictability in cross-border trade transactions by making investors know in advance of their customs duty liability. As the ruling given by the authority is binding on the applicant as well as government, it brings certainty to duty liability. As the ruling is pronounced in a time-bound, transparent and inexpensive manner, it helps in the faster clearance of goods. It further reduces the probability of further litigations. Therefore, it helps the importers and exporters in financial planning and taking informed business and supply chain decisions. Chapter 5B of the Customs Act 1962 contains the legal provisions in respect of Customs Authority for Advance Rulings. The procedures are governed by the Customs Authority for Advance Rulings Regulations 2021. The authority is an officer of the rank of Principal Commissioner or Commissioner of Customs. Currently, there are two such authorities in New Delhi and Mumbai. Their respective jurisdiction is shown on the map. The jurisdiction depends on the address of the applicant. If the applicant is from outside India, the jurisdiction lies with Delhi. Any importer and exporter or a person with a justifiable cause can make an application to the authority. Applicant not based in India may authorize any person resident in India to represent him. Applicant can file an application seeking advance rulings on the classification of goods, the rate of duty, valuation of the goods, applicability of notifications, determinations of the origin of the goods, any other matter as the central government may notify. But if the question raised is already pending in the applicant's case before any officer of customs, the appellate tribunal or any court, or the same as in a matter already decided by the appellate tribunal or any court, then the matter will not be decided by the authority. The applicant desirous of obtaining an advance ruling should make an application to the jurisdictional authority. The application has to be filed in CAR 1 form in English or Hindi, accompanied by a fee of 10,000 rupees. The applicant should ensure the following while filing the CAR 1 application. Give a complete description of goods, highlighting important features. Provide all relevant facts accompanied by evidence. Applicant's interpretation of the issue along with supporting arguments justifying the stand. A complete overview of the procedure after filling up the form is explained here. The applicant files an application in CAR 1. Upon receipt of the application, the Secretariat of the authority reviews it. In case of any defect or deficiency, the applicant is informed about the same and is required to resubmit the rectified form. In case there is no defect or deficiency, the application is forwarded to the Jurisdictional Commissioner for comments. The Jurisdictional Commissionerate is required to scrutinize the application on the grounds of admissibility as well as merits. They are required to forward their comments along with their opinion on the subject matter to the authority within 2 weeks. Their comments should include relevant records, their interpretation of the issue, along with the practice followed by them in respect of the subject matter. On receipt of the comments, the application is examined for its admissibility. If the application is found non-admissible, a personal hearing is held by the authority in order to give an opportunity to the applicant to be heard. After the hearing, if the application is still found to be non-admissible, an order rejecting the application is passed by authority. But if the application is found to be admissible after the hearing and is allowed to be heard further on merits, the comments of the Jurisdictional Commissionerate are forwarded to the applicant for their response. A personal hearing on the merits of the case is then held with the authorized representatives of the applicant and the department. An authorized representative appearing for the applicant or the Jurisdictional Commissionerate needs to submit an authorization document to the Secretary. The hearing may be conducted in physical or virtual mode. Details of the medium of hearing will be shared with both the applicant as well as the Jurisdictional Commissioner by the Secretary in advance. Thereafter, a ruling is issued by the authority. This entire process is required to be completed within 3 months' time. If the applicant and the Jurisdictional Commissionerate agrees with the ruling, the same becomes binding on both. The ruling continues to be in force as long as there is no change in law or facts or 3 years, whichever is earlier. If the applicant or the department does not agree with the ruling, they can file an appeal to the High Court within 60 days from the date of the communication of such ruling or order. The High Court may condone the delay for a further period of 30 days in case of reasonable cause. In case the appeal is filed by the applicant, it is the responsibility of the Jurisdictional Commissionerate to represent the department as well as CAR in the judicial forum. An applicant may also withdraw his application from the authority at any time before the pronouncement of the ruling. The authority can amend its order to rectify any mistake apparent on the record. Such a mistake may be noticed by the authority on its own accord or brought to its notice by the applicant or the concerned Jurisdictional Commissioner. An advance ruling shall be nullified if the authority finds that the applicant obtained the advance ruling by fraud or misrepresentation of facts. In such a situation, all the provisions of the Customs Act shall apply to the applicant as if such an advance ruling had never been made. An order declaring an advance ruling to be void can be passed only after hearing the applicant. The Customs Act makes a comprehensive provision for advance rulings to ensure that customs disputes are minimal. The provision is a major facilitator in achieving the government's objective of enhancing ease of doing business in India. For more details, please visit www.cbic.gov.in.